Have you ever wondered if a company already has a managing director, executive directors, chief financial officer, company secretary, and experienced promoters? Then why does the Companies Act insist on appointing independent directors? Can a promoter become an independent director? Can the son of the managing director become an independent director? Why are independent directors considered the backbone of corporate governance? And why are they so important in protecting minority shareholders? Today, we'll answer all these questions with practical examples and case studies that will make Section 149 easy to understand. So stay with me till the end because this chapter is one of the most important topics for CS Executive, CS Professional, CA Final, CMA, and Corporate Governance Professionals. What you will learn today. In today's video, we will learn why the concept of independent director was introduced, the legal framework under the Companies Act 2013, which companies are required to appoint independent directors, the qualifications prescribed under Rule 5, practical examples from listed companies, real-life case studies, frequently asked examination questions, secretarial audit checkpoints, and finally, I'll also share a simple memory trick to help you remember the entire concept for your examinations. Welcome. Hello everyone. Welcome back to Corporate and Securities Law Compass. If you're preparing for CS Executive, CS Professional, CA, CMA, LLB, or you're a company secretary, lawyer, compliance professional, director, or investor, this channel is dedicated to simplifying the Companies Act, SEBI regulations, FEMA, IBC, and corporate governance through practical explanations and real-world examples. If you are new to the channel, don't forget to subscribe and press the bell icon so you never miss any important legal updates. Question 1. Why was the concept of independent director introduced? This is one of the most frequently asked questions in CS professional examinations. The answer is simple. Before the Companies Act 2013, many companies had boards dominated by promoters and executive management. While promoters play a vital role in building a business, there is always a possibility that decisions affecting minority shareholders, related party transactions, executive remuneration, or corporate governance may require an independent and objective review. To address this concern, the Companies Act introduced the concept of an independent director. An independent director acts as an unbiased voice in the boardroom. Their role is not to oppose management, but to ask the right questions, evaluate proposals objectively, and ensure that decisions are taken in the best interests of the company and all stakeholders. Question 2. What are the objectives of appointing an independent director? The main objectives are strengthening corporate governance, protecting minority shareholders, ensuring transparency, preventing conflict of interest, monitoring management, improving investor confidence, enhancing board effectiveness, promoting ethical decision-making. Question 3. Which legal provisions govern independent directors? The legal framework includes Section 149 of the Companies Act 2013, Section 150, Section 152. Rule 5 of the Company's Appointment and Qualification of Directors Rules 2014, Schedule 4 of the Companies Act 2013, and for listed entities, the applicable provisions of the SEBI, Listing Obligations and Disclosure Requirements Regulations. Question 4. What qualifications should an independent director possess? Rule 5 states that an independent director should possess appropriate skills, knowledge, and experience in one or more fields such as finance, law, management, sales, marketing, administration, research, corporate governance, technical operations, or any other discipline related to the company's business. This means the law does not require every independent director to be a chartered accountant or a company secretary. A retired judge, scientist, banker, engineer, professor, or senior administrator may also qualify, provided they satisfy the statutory requirements. Practical case study. Suppose ABC Pharmaceuticals Limited wants to appoint Dr. Sharma, who has worked in pharmaceutical research for 35 years. Would he qualify as an independent director? Yes, his expertise is directly relevant to the company's business. Now consider another situation. XYZ Infrastructure Limited appoints a person solely because he is a close friend of the promoter, without any relevant expertise or experience. Can the board simply call him an independent director? No. The board must honestly form an opinion that the individual possesses integrity and relevant expertise as required by the Companies Act. Examination question. Here's an important CS professional question. Can the son of the managing director be appointed as an independent director? The answer is no, because an independent director must satisfy the statutory independence criteria under Section 149(6), including the restrictions relating to relationships with promoters and directors. Quick memory trick. Remember the word I govern. I, integrity. G, governance. O, objectivity. V, vigilance. E, ethics. R, relevant expertise. N, neutral decision making. Whenever you think of an independent director, think I govern. Recap. Let's quickly revise what we learned today. Why independent directors were introduced. Objectives of independent directors. Legal provisions governing their appointment. Qualifications under Rule 5. Practical examples. Examination questions. A memory trick to remember the concept. Next video teaser. In the next video, we will discuss one of the most important provisions of Section 149. We'll answer questions like, what is a pecuniary relationship? Can an independent director's relative take a loan from the company? What is the 50 lakh rupees limit? Can an independent director provide a guarantee? We'll explain these provisions with practical case studies and examination questions. You won't want to miss it. Call to action. If this video helped you understand the concept of independent directors in a simple and practical manner, please like this video and share it with your friends preparing for CS Executive, CS Professional, CA, CMA, or working in corporate compliance. Subscribe to Corporate and Securities Law Compass and press the notification bell to stay updated with in-depth explanations of the Companies Act 2013, SEBI regulations, FEMA, IBC, and corporate governance. Thank you for watching, and I'll see you in the next video. Until then, keep learning and stay compliant. Welcome to Corporate and Securities Law Compass. The content published on this channel is intended solely for educational, academic, and informational purposes. The videos are designed to help students, professionals, directors, investors, and compliance officers understand corporate and securities laws in a simple and practical manner. The explanations are based on the Companies Act 2013, SEBI regulations, FEMA, IBC, applicable rules, notifications, circulars, and publicly available information as available on the date of recording. Since laws and regulatory requirements are subject to amendments and judicial interpretation, viewers should always refer to the latest legal provisions and seek professional advice before acting on any information discussed in these videos. The views expressed are personal and do not represent the views of any employer, professional institute, regulatory authority, government department, or any other organization. References to companies or case studies are made only for educational purposes and should not be interpreted as recommendations, endorsements, or legal opinions.